Welcome to the Deep Dive, where we break down complex topics into the essential knowledge you need.
Glad to be here.
Today, we're tackling MPP, Section 603, that's Supplemental Oath or Declaration.
Right, and this fits into our ongoing journey through the Manual of Patent Examining Procedure, specifically Chapter 600, which deals with the application's parts, form, and content.
So our mission today is really to pull out the key info on this section, Section 603. We want to get you a clear understanding of, how and when you can file these supplemental oaths or declarations.
Exactly. Think of it like this. You filed your application, but, there's an issue with the inventor's oath or declaration that was submitted. How do you fix it? That's what 603 addresses.
And a big piece of the story, as the source material highlights, is how the rules changed. It really hinges on when the application was filed, doesn't it? Specifically around the America Invents Act, or AIA.
Precisely. That date, September 16, 2012, is the dividing line. The process looks different depending on whether your application was filed before that date or on or after it.
Okay, so let's start with the basics. What's the fundamental purpose of MPEP Section 603?
At its heart, it provides the official mechanism, the pathway, for applicants to submit a supplemental oath or declaration.
And why would you need to do that? What kind of problems does this fix?
Well, you'd use it to correct deficiencies or inaccuracies in the oath or declaration you already filed. Maybe a statement was missing or some detail like citizenship or an address was incorrect.
Got it. So correcting mistakes in that initial inventor statement.
Yeah.
And as you said, the rules split based on that September 16th, 2012 date.
They really do. Let's tackle the more current situation first. Applications filed on or after September 16th, 2012. The post-AIA world.
Okay, what's the main rule we need to know there?
The governing regulation is 37 CFR 1.67. That's the rule that explicitly allows you to submit a supplemental inventor's oath or declaration.
And when you file the supplemental one, does it have its own set of requirements, or does it need to meet the original standards?
It needs to meet the standard requirements. So it has to comply with 37 CFR 1.63 for regular oath or declaration, or 1.64 if it's a substitute statement, or even 1.162 for plant patents. Basically, the correction itself needs to be compliant.
Makes sense. And the errors it can fix. Things like missing statements, address mistakes.
Yeah, exactly. Missing required statements, maybe clarifying inventorship information as it was stated, or correcting a mailing address, that sort of thing.
Okay, but here's where it seems to get a bit tricky. What if the issue isn't just a typo, but actually involves changing who the inventors are? Like adding or removing someone?
Good question. And that's a critical distinction. If you need to change the inventorship itself, you cannot do that solely through a supplemental oath under 1.67.
Why not?
Because inventorship changes have their own dedicated rule, 37 CFR 1.48. That rule has specific procedures, often requiring statements explaining the error and how it occurred. A simple supplemental oath doesn't cover all those requirements, so inventorship changes are handled under 1.48.
Okay, that's a really important point. So 1.67 for correcting statements by the listed inventors, but 1.48 for changing the list itself.
Precisely.
What about something simpler, like just fixing a mailing address?
For that, the MPP actually points out you have another option. You can use a supplemental declaration, but often it's easier to just file an application data sheet, or ADS, under 37 CFR 1.76 to correct only the address.
Okay, so the ADS might be simpler for just an address fix. Now, a big question for these post-AIA filings. Who actually needs to sign the supplemental oath or declaration? Is it all the inventors again?
No, and this is a key difference from the old rules. For post-AIA applications, the supplemental oath or declaration only needs to be signed by the specific individual whose previous oath or declaration contained the error or is being replaced.
Oh, interesting. So it's targeted just to the person whose information needs fixing.
Exactly. If Inventor A's address was wrong, only Inventor A needs to sign the supplemental declaration correcting it. Inventors B and C don't need to do anything extra if their declarations were fine.
And that leads to another point. If an inventor already filed a fully compliant declaration, the USPTO won't make them file another one just because a co-inventor needed to submit a supplemental one, right?
Correct. The MPPP makes that clear. If you've already submitted a declaration that meets the requirements of 35 U.S.C. Section 115 and the relevant rule like 1.63, you're good. No need for an additional filing from you just because someone else is correcting theirs.
Okay, so summarizing the post-AIA situation, You use 1.67, signed only by the individual being corrected, for statement errors, but not for inventorship changes. That's 1.48. And maybe use an ADS for just address fixes. What's the absolute showstopper, the big limitation across all of this?
This is fundamental patent law, really.
Yeah.
No new matter. You cannot introduce new technical information into a non-provisional application after its filing date. Period.
Even through a supplemental declaration.
Even then, the supplemental declaration is for correcting formal aspects of the inventor statement, who they are, that they made the required statements their address. It's not a vehicle for adding new details about the invention itself that weren't in the original specification.
Ah, right. You're fixing the paperwork about the inventor, not adding to the invention's description. Trying to sneak in new technical details would be introducing new matter.
Exactly. And that can have serious consequences, potentially invalidating claims later on. So stick to correcting the declaration's formalities.
Okay, that covers the post-AIA landscape. Now let's shift gears and talk about applications filed before September 16th, 2012, the pre-AIA rules.
Right, governed by the older pre-AIA version of 37 CFR 1.67.
Were the reasons for filing a supplemental oath similar back then?
Largely, yes. Correcting errors like an omitted mailing address, maybe listing the wrong citizenship, or importantly, forgetting to include the clause acknowledging the duty to disclose material information to the USPTO.
But the big difference was in the signing requirements, wasn't it?
That was a major difference. Under the pre-AIA rules, the supplemental oath or declaration had to identify the entire inventive entity, all the inventors.
Okay, so it listed everyone, but did everyone always have to sign it, like for any little correction?
Not necessarily everyone, every time. This is where it was more complex than the post-AIA rule. The pre-AIA supplemental oath had to be signed either by all the inventors, or it could be signed only by the inventor or inventors affected by the specific correction being made.
Okay, so it depended on the nature of the error. The examples in the source material seem helpful here. Can we walk through those?
Definitely. Let's take the first one. Say you had inventors A, B, and C. They all filed a declaration, but oops, inventor C's citizenship was listed incorrectly.
Okay. Under pre-AIA rules, who signs the correction?
In that case, since the error only affected inventor C's information, only inventor C needed to sign the supplemental declaration to fix their citizenship, even though the form identified A, B, and C.
Got it. So if it's a specific personal detail, only that person signs. What if the error was more general?
Example 2 deals with that. Imagine the inventors forgot to include the required duty to disclose acknowledgement clause in any of their declarations. A pretty significant omission.
Right. So who signs then?
In that pre-AIA scenario, because the omission affected the declarations of all inventors, then all inventors, A, B, and C, would have had to sign the supplemental declaration to add that required clause.
Okay, that makes sense. All affected means all sign.
Yeah.
What about a middle ground?
Example 3. What if inventors A and C included the duty to disclose clause, but inventor B just forgot it in their individual declaration?
So only B's declaration was deficient in that specific way.
Exactly. Under the pre-AIA rules, in that case, only inventor B would need to sign a supplemental declaration to correct their specific omission.
It seems the pre-AIA rule also tried to target the correction, but the overall document structure mentioning everyone was different.
That's a good way to put it. And one more pre-AIA scenario. What if an inventor was deceased? Example 4 covers that. If an inventor had passed away before the correction could be made, their legal representative, like an executor or administrator of their estate, could submit the necessary correction on their behalf.
Thanks. Those examples really clarify the pre-AIA signature complexities. It definitely underscores why knowing that filing date is so critical.
Absolutely. Now, there are a couple of general points about supplemental filings that apply regardless of the AIA date, unless noted otherwise.
Okay, like when you can actually file them. Is there a strict deadline early on?
Actually, no, not necessarily an early deadline imposed just for filing them.
Yeah.
The sources say you can file a supplemental oath or declaration quite late, even after the application has been allowed. It's considered a matter of right to correct those deficiencies.
Even after allowance. That's surprising.
Yeah, maybe an error is only caught during the final review before paying the issue fee. However, there's a big but. If the office specifically requires you to file an oath or declaration, maybe because one was missing entirely or is fundamentally flawed, and they set a deadline, like in a notice requiring a declaration or in the notice of allowance itself, then you absolutely must meet that deadline.
Ah, okay. So you can file voluntarily late, but if the USPTO demands it by a certain date, usually with the issue fee payment.
Then you have to file it by that date to avoid abandoning the application.
Makes sense. And what about the function? Does filing a supplemental oath count as an amendment to the application?
No, absolutely not. And this is another crucial distinction. Supplemental oaths or declarations correct the inventor's statement itself, the formal declaration document. They do not amend the application's text, like the specification, claims, or drawings.
So you wouldn't file it under the rule for amendments after allowance, like 37 CFR 1.312?
Definitely not. Rule 1.312 is for changes to the application's substance. Supplemental oaths are about the formalities of the inventor's declaration. Different purpose, different mechanism.
Got it. Fixing the form, not changing the substance.
Precisely. It's about ensuring the legal requirements related to the inventor's identity and their sworn statements are met.
Okay, let's pull this all together and connect it back to the listener. Why should you, listening now, care about all these details in MPP Section 603?
Well, if you're involved in the patent process at all, getting that inventor's oath or declaration right from the start is ideal, but knowing how to fix it correctly if something goes wrong is just critical.
It's not just avoiding a procedural slap on the wrist, is it?
Far from it. An error in the oath or declaration, if not properly corrected, isn't just a minor issue. It could potentially lead to the application being held abandoned by the USPTO. Or, maybe even worse, it could be a basis for challenging the validity of the patent years after it's issued.
Wow. Okay, so the stakes are pretty high for what might seem like paperwork.
They really are. Understanding these rules, the difference between AIA and pre-AIA, who needs to sign when, what constitutes a correctable error versus an inventorship change, and crucially, remembering the no new matter rule. All of this helps ensure your application stays compliant and legally sound throughout its life. It's about protecting the integrity of the potential patent right.
It really highlights how process and substance are intertwined in patent law.
Definitely.
Before we wrap up, we really want to give a special thank you to Mike Shepard. He's the creative director who organized this entire MPP audio series.
Yes, thanks, Mike. And we also need to include our standard disclaimer. Please remember, this summary was put together using AI tools, specifically ChatGPT and NotebookLM, and while we aim for accuracy, there might be errors or omissions.
That's right. This is for general information and education only. It's definitely not legal advice.
For any authoritative guidance, you absolutely need to consult the official MPP text, talk to a qualified instructor, or get advice from a registered patent practitioner.
So, to recap our deep dive into MPP Section 603. Supplemental oaths and declarations are your tools for fixing inaccuracies in the inventor's statement. But as we've discussed, you've got to pay close attention to the details, especially whether your application is pre-AIA or post-AIA, as that dictates who signs and how.
And always keep that no new matter rule front and center when making any corrections.
Exactly. Which brings us to a final thought for you to consider. We talked about that strict rule against adding new matter, even when you're just trying to fix something seemingly formal like the inventor's declaration. How do you see that balance? The system lets you fix declaration errors, which seems fair, but draws a very hard line against using that fix to expand the invention's scope.
It's a tension, isn't it?
It is. Think about how getting that initial inventor statement as accurate as possible right from the beginning can potentially save a lot of trouble later, maybe avoiding situations where a necessary correction gets tangled up with that tricky new matter prohibition. Something to mull over.